Well, welcome everybody. My name is Marty Mascari. I'm with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC. The ADRC is a project under the Area Agency on Aging, and I'm a contractor with them. And once again, we're welcome to have, and we're very pleased and blessed to have Francis Espinoza and Camille Brown with the North Texas Fair Housing Center to talk about 2 legal ways to break a lease in Texas. But before we get started, if we could advance the slide, I want to talk a little bit about the CEUs and go over that. Today we're offering complimentary CEUs for licensed social workers and licensed professional counselors in Texas. And just so you know, although these are the ones we're set up to do, I know people have taken CEUs and used them for other licenses in Texas and for licenses outside of Texas. But I know that all secondhand. So we're not set up with them, but you're more than welcome to go through the process and get a certificate and submit it to whatever authority you might be licensed with and ask them if they'll accept the CEUs. That's up to you. There's no guarantees of that. We're only set up again with social workers and professional counselors in Texas. You can also get a certificate of attendance is available. If you'd like, today we're offering 1.5 classroom hours of CEUs. You must complete the entire live webinar, and there's not a recorded one, so it's just live webinar. That's an error from our Medicare Mondays, I think. But you must attend the entire live webinar because we have to have the record from Zoom showing that you were on. Then, in addition to that, you must complete the Google survey that will pop up, hopefully, as you close out of Zoom today. Some of you I know have pop-up blockers on your computers, or your company does. If that's the case, you'll also be getting that link in my follow-up email that will go out later today about today's webinar. We ask everyone to fill out the Google survey. It's not only for CEUs and for certificate of attendance, but it's also for our funding source in part of the goals and objectives we've set out when we applied for the funding to be able to do these. The Google survey will be up and available to you until 5 p.m. a week from today. And then if you'll give me another week to get the CEU certificates out, and I know I am behind from being out of town. I've had several technical issues and I'm working to get caught up. So if you haven't got some of them from last month, we're still working on those, but we should be caught up by the time we get to the 1st of June. And so that being said, I want to turn it over to Francis Espinoza, the Executive Director of the North Texas Fair Housing Center.
Thank you, Marty. As Marty said, my name is Francis Espinoza, and I'm the Executive Director of the North Texas Fair Housing Center. Today, we're going to talk about 2 legal ways to terminate your lease in Texas. And so Camille Brown, who is our Director of Advocacy and Education, she's actually going to start off the presentation and talk about domestic violence, and then I'll take over later and talk about disability. So I want to turn it over to Camille so she can introduce herself and start the presentation.
Great. Thank you, Francis. And good morning, everybody. My name is Camille Brown, Director of Advocacy and Education here at the North Texas Fair Housing Center. We're going to start with protections that allow for people who have been victims of some sort of domestic violence or assault to break their lease. And so we'll start with kind of the laws that we base this on, these protections when we do our advocacy. And that is called the Violence Against Women Act, which was passed in 1994 under the Clinton administration, with the rest of that kind of sweeping crime bill legislation that was being passed at that time. And it has since been reauthorized in Congress a few times, and expanding different protections and programs under the act. So it provides protections for victims of domestic violence, dating violence, sexual assault, or stalking, okay? Now, these protections, they work similar to reasonable accommodations in disabilities, and that's why we have these kind of two topics together, because they kind of follow the same format. And they're essentially just changes or exceptions to standard policies and procedures for someone who has experienced these issues. And they're available to all individuals regardless of sex, gender identity, or sexual orientation. So even though it is called the Violence Against Women Act, all genders are also provided protections under this act. And if you have questions as I move through, please put them in the chat and we'll try to answer as we go through. So once someone has experienced these issues, there needs to be some sort of documentation that they are covered under the act. And it works a little bit differently in public housing authority or government subsidized properties versus your kind of typical fair market apartment complexes or single family homes. So a lot of these apply specifically to institutions that are public housing authorities or somehow otherwise subsidized, but I'll make those distinctions as I move through. So one way that a person can document their status as a covered person is a signed certification by a service provider, attorney, medical, or mental health professional from whom the covered person sought assistance. So this isn't a situation where a tenant or applicant may need to release medical records or provide a doctor's note or anything like that, like you do with a reasonable accommodation or disability, but some sort of hospital report or medical report can work if you sought assistance from a mental health professional, a therapist, psychologist. That could also work. An attorney if you have some sort of legal documentation or paperwork. And then lastly, a victim service provider. So if a tenant or applicant sought refuge at a shelter, then somebody who works at the shelter, a counselor, intake coordinator, family service provider, they can then write a letter or submit some sort of document attesting to the person's status. Now, when you have someone who is using their stay at a domestic violence shelter, then that serves as proof outside of any corroborating evidence, such as a medical report, a police report, or anything like that. So if they sought refuge at a shelter, because shelters have their own kind of threshold or bar for services that they provide, we usually are able to go with that to solidify a person's status as being covered by the VAWA protections. Next is a record of federal, state, tribal, territorial, or local law enforcement agency, court, or administrative agency. So this is going to be your restraining orders, your any other type of civil protection or any type of protective order given to you by a judge. Like I said, if you have a police report, if the incident maybe happened at the mall and a security guard broke it up and there's a statement there, that also works. And then lastly, a statement or other evidence provided by the applicant or tenant. Now, this can be accepted at the discretion of a housing provider, especially when you're dealing with multifamily housing or a single family home that you're renting from a landlord that is not subsidized by the government in any way. They are allowed to ask for a police report or something else to corroborate if a tenant or applicant maybe just wants to submit a statement that is at the discretion of the provider outside of subsidized properties. Now, housing providers may also accept verbal requests for VAWA protections, and they also cannot require more than one type of documentation. So if you have a police report, you don't also need to submit any records from a hospital stay. If you have a letter from a service provider at a shelter, you don't also need a police report, right, to corroborate that. And so a housing provider must also allow at least 14 days for a response on both sides. So if you present that request verbally, let's say you stop by the leasing office and the tenant or applicant has a confidential conversation with a leasing agent or a manager on site or the landlord, there is a 14-day period to be allowed for a response from that housing provider. Now, when you're dealing with public housing authority, there's also a self-certification form, and the form number is there. So that's also an option that will also trigger the VAWA protections. And when you're dealing with housing authorities, they have certain protocols that they have to follow, and this HUD form will also trigger their process, right, for dealing with a VAWA protection. And again, non-subsidized landlords may request a protective order. So before we'll answer a couple of questions from the chat, but we have a Q&A just to wake y'all up, see if y'all have been paying attention. So type your answers into the chat, and there may be more than one answer. So which of the following can identify someone as a person in need of VAWA protections? You're going to type your answers into the chat. A case manager at a domestic violence shelter, an incident report from security on property, C, an anonymous letter from a neighbor, D, a written statement from the tenant, or E, all of the above. So I'll let some of these answers come through. Okay, almost everyone is saying E. I'll wait a couple seconds to see if we have any dissenters. We have someone who put A. Okay, almost everyone put E, and almost everyone is incorrect here. This was a bit of a trick question. So let's go through the answers. A case manager at a domestic violence shelter can absolutely identify someone as a person in need of those protections. They qualify as someone who would be kind of a victim health service provider. An incident report from security on property. So that would fall under the second category, right? So anyone, any kind of state or local authority, administrative agency, anything like that, they would be able to identify you. C, an anonymous letter from a neighbor. So we have one person in the chat who got it right, who may have also be cheating a little bit, but the anonymous letter from a neighbor cannot identify someone as a person in need of our protections. It might alert management that there is a situation going on property that may need to be monitored, but an anonymous letter from a neighbor does not work because the identification needs to come from an applicant or a tenant, the applicant or tenant themselves, right? It can't even be maybe a family member, right, who wants to drop by and give some information to the people on property. So an anonymous letter from a neighbor does not work because the tenant or the applicant needs to be directly involved in identifying themselves as someone in need of those protections. Now, D, the written statement from the tenant would absolutely work in this situation, but that's also a bit of a trick question because, again, remember, written statements are at the discretion of the housing provider, especially when you're dealing with housing that is not subsidized in any way. And so the answer here would be everything but C. Okay, so once you have identified a person as in need of these protections, what remedies can be provided? So this first set of remedies applies to public housing authorities, and the difference here is really just the verbiage between subsidized properties and non-subsidized properties, right? So a lease bifurcation is just a setup that allows you to separate the people who are on the lease or remove someone from the lease. So if the person who is experiencing violence or assault or stalking is actually on the lease with the person perpetrating that abuse, then the housing authority can just go in and pull the offender off of that lease if they want to stay on property. And I've seen this in a few contexts where the person want to stay on property because maybe their abuser is going back to a country of origin, or maybe they've been arrested or something like that, where they don't feel threatened by staying in their current unit. And so they just remove the person, especially if you have a voucher. Family breakups. Now, this is when you want to just completely split the voucher or split the lease to two separate entities. You have your own, they have their own, right? They're not going anywhere, and neither is the victim. So this qualifies as a family breakup as opposed to a lease bifurcation. And then there's finally an emergency transfer plan, which allows for a person to skip over some of the red tape involved with being transferred if they have a voucher or if they're getting assistance, or if there's, some sort of three-way lease between an agency, the tenant, and the housing provider. And the transfer plan can allow you to transfer one property. It can help with moving your voucher to another housing authority, city, or county. And again, it allows for the person to bypass that red tape and transfer more quickly for their safety. And this remedy also allows for exceptions for policies against police activities. Now, this can also play out in non-subsidized housing, but a lot of PHAs have policies related to police activity or someone being arrested or committing what can be identified as a crime on property. So let's say you have a domestic disturbance where both people get arrested, right? And, they both just get taken in and booked, but it's a domestic violence situation. And so instead of triggering the process that starts for an eviction, in those situations, we can apply for an exception because it was a domestic violence or domestic abuse situation. And it also includes a release from that 12-month lease obligation, right? Because usually when you're signing a contract with the housing authority, it requires at least a 12-month lease. But let's say an incident happens 1 or 2 months into your lease, then you can also get removed from those obligations. Now, the transfer plans can be, I'm answering a question from the chat. The transfer plan can be triggered at any time, right? Because it is centered around an incident or several incidences or just a decision that's being made to leave. So it doesn't need to be set up before, during you sign a lease. It really revolves around the incident themselves and the decision that a person makes to identify someone in need of those protections. Now, when you're talking about non-subsidized housing, there are a lot of places now that are including nuisance ordinances in their leases. And what that might speak to is if the police have to come out a certain number of times within a certain time period. So the lease might say if there are 3 police calls to your unit within a 60-day period, then that triggers nuisance ordinances and can count as a violation of the lease. But obviously in situations like this, when the police are called, the person who is in need of those protections, we feel like shouldn't be penalized for that nuisance ordinance or a lease violation due to that situation. And then also in non-subsidized housing, these protections allow for the breaking of a lease with no penalties or also transferring buildings. And so I want to take a moment right here to also mention sexual assault in this context, because it doesn't necessarily have to be a violent situation or a series of violent incidences. And again, not gender neutral. So I'm sorry, and again, it is gender neutral. So if you have a situation where, and I'll use this as an example, there was a person who was a resident there. They had just signed their lease, had been there maybe a month and some change, and decided to have kind of a get together or a gathering to meet his neighbors, and invited a few people from his building, his floor. And at that particular get together, he was sexually assaulted by one of his neighbors, right? And so we were able to get that person transferred. When you're dealing with property management companies, you can get someone transferred to a different building on property, or if it's one of the larger ones, like maybe an MAA or a Gray Star that may have properties all over the city, you could also transfer to different properties that are being operated by that same management company. And again, it allows for the breaking of a lease without fees or penalties. And then we'll do this Q&A. We'll do the Q&A, and then I will address a couple of comments in the chat. So again, type your answers into the chat. Which of the following can be provided to someone experiencing a domestic situation? Again, there may be more than one answer. So which of the following can be provided to someone experiencing a domestic situation? A, are they allowed to break their lease? Are they allowed to transfer to another property owned by the management company? C, make an exception for past eviction when considering an application. B, removing a member of the household from a voucher. Or E, all of the above. So we have a lot of E's. We have an ABD. ABD. Some more E's. I'll give y'all a few more seconds to chime in. Looks like we're tied between ABD and E. Okay, so I think the last trick question has y'all on y'all's toes, because this one, the answer here is actually E, all of the above. So let's go through these. Breaking their lease, we talked about that. We talked about transferring to another property owned by the same management company. But what we didn't talk about was making an exception for past evictions when considering an application. And this is actually adjacent to one of the questions that's been asked in the Q&A about difficulty securing another property once you've gone through this process and broke your lease somewhere else. So VAWA protections not only apply to tenants, but they also apply to applicants. And a most recent example we've had here with the North Texas Fair Housing Center was we had someone who was applying for she was transitioning out of a shelter and was applying at a newly built affordable housing complex that she really wanted to be in. However, there was an outstanding debt from her past living situation where she essentially just kind of fled the situation to a shelter, didn't get her name taken off the lease, and the person that she shared the lease with had stopped paying, got evicted. So all of this was on both of their names. And so she was having difficulty applying at her next unit. And so what we ended up having to do in that situation was reaching out actually to the apartment complex where she used to stay. And fortunately, and because she was having some difficulty procuring the police report, fortunately, there was someone on staff at the leasing office who remembered that situation from when she was there. And they had already gone through the process of trying to clear our client's debt. However, it was still coming up on her credit report and in her background check and search. So we were able to secure just a letter on the letterhead from that past leasing office that she was able to take to her new place or her potential new place and show, this is something that's not on my name and it's in process of being solved. Can you make an exception for this consideration when looking at the rest of my qualifications for the application? And she ended up being able to stay there. So it may require a little bit of additional advocacy and maybe a little bit of, reaching out, research, and some other corroborating documentation. But exceptions can be made for people who have experienced these situations when they're looking for new properties, if they've had evictions or something like that that's related to a domestic violence situation. And I will, okay, and John will connect offline about the question that you asked in the chat. And so again, as we move through the presentation, and if you think of any questions, just type them into the chat. I am going to transition over to chat watching duties, and I am going to transfer it to Francis to talk a little bit about the property code and then protections for people with disabilities in these situations. Francis?
There was also a question in the chat, and I don't know if we addressed this, so it says, if a tenant has experienced domestic violence but declined to get an EPO, can the landlord still evict them because they are allowing the perpetrator to be on the property? There are police reports on the incidents, and the housing provider has knowledge of these incidents.
Oh, can you repeat the question? I was trying to see if I could read it for myself.
Yeah, it's way back in the chat.
Okay, okay.
It came in early on. So the person is asking if the DV victim didn't get a protective order, can the landlord evict them? Because they're allowing the perpetrator to be on property.
Right. No. So that's, again, a protective order or something like that is one type of documentation to qualify someone as a covered person, but it is not the only type that is to be accepted. And it also doesn't need to be a protective order itself. Now, this sounds like it might be non-subsidized housing. And so they are able to request some sort of police report, but a restraining order, that's not necessary. And then also, if they are able to provide any other sort of documentation, like I said, if they sought refuge at a shelter, if they talked to a therapist, if they had to get treatment at a hospital, and then also they can also provide that written statement to identify themselves as that. But the eviction about calling the police too often, again, that's something that we can ask for exceptions for, because that would qualify as like a lease violation under a nuisance order, and we can seek our protections in that situation. But again, a restraining order is not the only way to provide documentation in that situation, and the landlord can't dictate the severity of a situation just based on what a victim did or didn't do to protect themselves in that situation. And again, our contact information is in the PowerPoint, and that's something that we can connect with offline if you're still working with that client.
Okay. So to close out the DV and sexual assault portion of the presentation, we also wanted to let you know that the Texas Property Code does have 2 sections that address this as well. So we've been talking about laws on a federal level, or Camille talked about VAWA and laws on a federal level. There's also Texas Property Code that addresses this. And the first section is 92.016, and that is related to family violence. And so in the code, it lists what somebody needs to show in order to terminate a lease and avoid liability for any future rent. Those 3 things that they can show, and it's one of the 3: temporary injunction, temporary ex parte order, or a protective order. And so one of the things about this section of the property code, though, is that it has to be one of these 3 things. So sometimes getting a temporary injunction might make the situation worse. It might inflame the situation again. And also a protective order, because it has to be served on the person that it's being filed against. So many times the laws that Camille spoke about might be better to use because they don't have these strict requirements. But then there's also 92.0161, which is the right to vacate and avoid liability following certain sexual offenses or stalking. And so this one is more flexible in what types of documentation you can show to be able to get out of your lease or terminate your lease early without any fees or penalties. So you can show a letter from a licensed healthcare provider who examined the victim. You can also show get a letter from a mental health advocate or mental health care service provider, or you can get a letter from a mandatory reporter, and that could be a social worker, for example, at a either at a medical care facility or for example a rape crisis center, something like that. And then also number 4, the protective order can also be used. And so the Texas Property Code seems to be a little more stringent on what you can show. So a lot of times using VAWA or even the Fair Housing Act, gender protection protects people against domestic violence. Those are, I think, stronger laws to use. So I'm going to go into disability right now because that's the other way that you can legally terminate your lease in Texas without any fees or penalties. So just to kind of give you some background information, of course, leases are contracts, right? So if you sign a contract, you have to meet its requirements, which means if it's 12 months, stay there 12 months. If it's 8 months, stay there for 8 months. But leases always have buyout provisions in them. So if you wanted to break your lease early, you can. You just have to pay what ends up being a pretty large penalty. It can be a month's rent, 2 months rent. There's also a reletting fee that can be anywhere from $150 to $250 on top of that. So you can break your lease, you just have to pay for it. And the 2 things that we're talking about today are the ways that you can break it, the only legal ways you can break it without then being held accountable for paying, you know, a fee or a penalty or paying out the rest of your lease. Somebody put in the chat a question about a neighbor who had mini strokes and was evicted for calling the EMTs too often. That's a violation of this person's Fair Housing Act rights to be protected as a person with a disability. So that's something that if the person was being evicted because they called EMTs too often and it was related to a health issue or a disability, that's where advocacy becomes really important, because that's something that we could assist with and that we can educate the housing provider on the Fair Housing Act and the protections for people with disabilities, because someone should not be evicted because they are seeking assistance for their medical condition. So it's sort of, you know, calling somebody to the property many times, but if it's related in this case to a health issue, it's illegal under the Fair Housing Act for this person to be evicted because of that. So I just wanted to kind of address that really quick, because I think that came up when Camille was talking about you know, police being called to somebody's apartment because of a domestic violence situation and being called several times in a month. That question came up about disability. But let's jump into disability. So who's protected? A tenant that develops a disability while they're living in rental housing, for example, or a tenant who has a disability, an existing disability, and they need different things because their disability has become more severe. So looking at, is there a cause of action to request this? So discrimination under the Fair Housing Act is refusing to grant an accommodation to somebody with a disability. A reasonable accommodation is a change or an exception to rules, policies, or procedures that the housing provider has in place. And typically those rules, policies, and procedures are going to apply to everyone. But the disability provision of the Fair Housing Act allows people with disabilities to request exceptions, which we call accommodations. So I wanted to just throw in here really quickly. So reasonable accommodations are changes or exceptions to rules, policies, and procedures, but there's also reasonable modifications, which are changes in the structure. So that can be adding grab bars in a bathroom. It could be adding a ramp where there are stairs for the entryway to the apartment, for example, or the housing. So under these modifications guidelines, the landlord does not have to pay for the structural changes. The burden is on the housing provider to allow the changes, but they don't have to pay for them. The one exception is if it's tax credit housing or affordable housing or some housing that gets a government subsidy, then they should have to pay for that to make the modification. But that's the only exception. So in regular market rate housing, the person with a disability will have to pay for the modifications that they want for their living unit, apartment, or if they're renting a single family home, they would have to pay for those modifications. Okay, so I think the elevator example is a really good one. So say a person with a disability, maybe somebody who lives on the second floor of a walk-up building and either wasn't disabled when they moved in or was, but their disability has progressed and become worse over time. So in that case, in a two-story apartment where really stairs are the only way to get to the second story, there's really nothing that can be done to make that apartment accessible short of putting an elevator in. And an elevator is going to be obviously really expensive and also may not even be feasible depending on the structure of the apartment. So this is the type of situation where the only choice may be for the person with a disability to leave the unit and move to a unit that's more accessible. So what is reasonable? Lease termination is reasonable if a tenant with a disability can no longer use the dwelling because it's become inaccessible. So that could be the second floor unit for somebody who cannot negotiate stairs anymore. But when you're talking about reasonable accommodations, you know, the key word is reasonable. So there may be other reasonable alternatives to terminating the lease early. It may be transferring units. So maybe there is a first floor unit that doesn't have any stairs up to its entryway. And it might be a more reasonable option for somebody to transfer to a first floor unit rather than just terminating their lease and moving off the property entirely. Another thing that might be more reasonable than terminating a lease would be to move to another property that's owned or run by the same housing provider. And that way the person will still be bound to their lease, but they will be able to transfer to a unit that's more accessible. So, you know, lease termination, I think when you're talking about lease termination, you also have to look at other options that might be more reasonable or better alternatives to terminating a lease. Oops, okay. So how does somebody make the request to terminate their lease early without any fees or penalties? So a tenant can make this request on his or her own. We always tell people do it in writing and keep a copy for yourself. So you have, you know, a copy and the date you submitted the request. And it can be a very simple request. It doesn't need to detail anything about the person's particular disability. And it can look something like this. I, the person's name, am a person with a disability. as defined by the Fair Housing Act. They have a right to request a reasonable accommodation, and then say what that accommodation is. I request to terminate my lease early without any fees or penalties so that I may move to an accessible unit. Some apartments have a reasonable accommodation request form, and it's okay if they tell you to fill out their particular form, but always, put it in writing. So either put it in writing yourself or use their form, and once you complete it, ask for a copy of that. So the tenant can make the request on their own, but we can also assist with that. So if the person wants us to, as advocates, to make their accommodation request for them, we can do that. Or we'll provide them a sample letter like this so they can make the request on their own, because sometimes people feel that, they want to try to do it first on their own before we get involved, because they're worried about, potential retaliation if the North Texas Fair Housing Center gets involved in their issue. So either way, we can help with that and do it for them, or we can provide them with the language just like this in the scene. You can use language just directly from this slide to make the request on your own. Okay, now the housing provider has the right to request verification of the disability. So the person makes their accommodation request, and the landlord doesn't have to, but it is their right to request verification. So there are several ways to provide verification. The first is the disability apparent. If the disability is apparent, then there really isn't any need for any further documentation of the disability. The person can also, the tenant can also provide a letter from a healthcare provider, a healthcare professional, and it isn't just an MD. They can get a letter from a doctor, therapist, social worker, occupational therapist, physical therapist. So any healthcare provider that the person is under the care of and knows what they need can provide this letter. And then another way to show verification is to show proof of Social Security disability benefits. And that usually is a printout letter that has the person's disability benefits listed for the month, or and they can use a copy of that to prove that they have a disability, to show that it is related to their request. Okay.
And here, Francis,
yes.
Could you take a moment to, I guess, here talk about the distinction between mental and physical disabilities when it comes to verification, and also speak to kind of the idea of someone being on meds versus off meds and how that can affect these requests.
Okay. So many times somebody with a mental disability, that's not going to be apparent. So if they're requesting an accommodation, they may not be able to use that as a means of verification. So typically somebody with a mental disability will have to give a letter from their healthcare provider to show that what they've requested is related to their disability. So in that doctor's letter, the doctor just has to say, my patient, or so-and-so is a patient under my care, and as a person with a disability requires XYZ. They don't have to detail what the mental disability is either. They just have to verify that what the person is asking for is related to their disability and needed for their disability. So for people with mental disabilities, they usually can need to show verification under category 2 and 3 on the slide. Somebody with, for example, who uses a wheelchair is probably going to be able to use the first one, is the disability apparent. Okay, so now people who have, for example, a mental disability and they're on medication for that, this sometimes comes into play if somebody went off of their medication and then something happened that was related to their disability. So those are really different from, that's a different issue from what we're talking about today. But just really briefly, I can tell you that if somebody goes off their meds and does something that is a lease violation and then are being, threatened with eviction or told they're going to be evicted or asked to move out, we can request an accommodation for that person, provided that the reason the lease violation happened was because they went off their meds, and that they have to commit to going back on their meds so that this won't happen again. And that's where, again, advocacy becomes really important. So that's something that we can assist with and explain to the housing provider, because somebody with a mental disability who is on medication and then goes off their meds for whatever reason, has a lease violation, should be given one more chance to remedy that situation. And again, it's going to take a commitment that they go back on their medication so that this doesn't happen again. But I'll give you an example of a case that I worked on with North Texas Fair Housing Center. I had a client who went off their meds and then caused a nuisance on the property, and the property had given them a notice to move out because of the lease violation, because the nuisance was they were harassing neighbors and bothering neighbors, and they wouldn't stop. So after we got involved, we learned that the person didn't voluntarily go off their meds. This was at the height of the pandemic, and whatever medication they were on, they couldn't get it. It wasn't available. And I guess the doctor didn't prescribe a different medication. It just didn't have the medication available to them. So involuntarily stopped taking it because they just didn't have any more, and then caused a nuisance on the property when they weren't under their medication anymore. So we got involved and worked with the housing provider and the tenant and explained the situation to the housing provider. The tenant by this point had been able to fill their prescription, had gotten back on their meds. And so we were able to get them that one more chance, that because it wasn't their fault that they couldn't find or access the meds, they weren't available. And so with a commitment by the tenant to get back on her meds and for this not to happen again, we were able to get them to rescind the notice to move so that she could continue living there.
And Francis, just a couple of more comments from the chat. The first is, what if the violation is criminal in a situation like this?
In a situation where if the person commits a criminal act, then, and the police are called and they're arrested or whatever happens after that, you can't get an accommodation for a criminal act. So, the disability law and reasonable accommodations are really case by case. Each one is specific in and of itself. And so we really take each case and look at what's going on and what's reasonable for that situation. But if somebody commits a violent act, then they're going to be held, they're going to have to face the consequences of whatever they did. And that may mean getting arrested, maybe being prosecuted for what they did. And there really isn't a way to get an accommodation around a criminal act. So what we're talking about here with, for example, the person going off their meds, they were just bothering other tenants and then were told they were going to be, and it was a lease violation. So we're really talking about lease violations here versus if we're not, criminal acts are a whole different thing. And there's no exception that a person with a disability can get for committing a criminal act.
All right. And then another comment is veteran with PTSD being triggered by noises upstairs, and the above tenant will not comply with turning the TV down. In that situation, we might be able to advocate for a transfer. But Francis, if you want to speak to kind of how this might affect behavior of the neighbors in a situation like that.
Yeah. So, it's unfortunate the neighbor upstairs won't turn the noise down. And also, the housing provider, if it is a noisy situation that's bothering more than just the person with a disability, the housing provider really should get involved to deal with that tenant. But if it's a specific issue related to noise that is affecting the person with a disability, then the accommodation there, like Camille had said, would be to transfer to request an accommodation to transfer to another unit. to get away from the neighbor that is just blaring their TV or whatever noise they're creating. And so in those situations where the accommodation is a transfer to another unit, then the transfer fee should be waived because the person needs the transfer because of a disability, not because they just want to move to a different unit. And a lot of times housing providers just don't know kind of all the nuances of the disability provisions. And, you know, it's like I said, it's really, there's a lot of gray area, and it's really you have to really look at each situation by itself and on a case by case basis. So that's where advocacy becomes really important, to work with the landlord and explain the situation and tell them what is needed.
And then finally, before we move on, I just want to address kind of some language here, just to be clear. When we're talking about accommodations, we're talking about a change in a policy or procedure that does not come with a cost, right? So that would be your exception to a no pets policy for someone who has a service animal or an emotional support animal. But then when we're talking about reasonable modifications, that refers to a change in the structure of the home and usually comes with associated costs. These are your ramps, your grab bars, lowering cabinets, things like that. And so just as Mayor's pointed out in the chat, if your housing is non-subsidized when it comes to modifications because they require costs, if the housing is non-subsidized, the landlord is required to grant the modification, but they are not required to pay for it. And again, there are organizations who have funds to assist with these requests, including the North Texas Fair Housing Center. So you can contact us if you know someone who is in that situation.
Thank you, Camille. So my next slide here is a sample letter from a doctor, and we have this available and can send it to a healthcare provider so that they have a template for how a doctor's letter can look. And if you read through it, it does not give any details about the disability. It simply says that this person requires this because they are a person with a disability. So, you know, at this stage, no one has to disclose the details of the disability. The reason why we provide this doctor's letter as a sample is that a lot of times doctors don't know that, and they might put something in the letter regarding the disability, and they don't have to do that. So. Okay, so I just wanted to go through some questions. So if y'all could just answer yes or no in the chat. Can a landlord tell you, I see you walking without your cane sometimes and you look fine. Why do you need to move downstairs? Right. No, they cannot tell you that. Can a landlord tell you your doctor needs to send me your medical records? No way. A housing provider does not have the right to see your medical records. Like I said before, their right is to ask for a verification of the disability if they want to. They don't have to, but it's their right to do that. But they don't have the right to access your medical records and look at copies of your medical records. Oops, sorry. Can a landlord ask you to pay a transfer fee to move to another unit? No, the transfer fee should be waived if you're transferring due to a disability. Can a landlord increase your rent when you transfer to a unit downstairs? Okay, so this is a tricky question because a lot of times, for whatever reason, first floor units, sometimes even if they're the same square footage as second floor, third floor, fourth floor units, they might cost a little bit more because I guess there's a benefit to living on the first floor. I'm not sure how apartments calculate these things, but you know, there could be other differences, like say the square footage is different. Or say the first floor unit has a little like green area attached to it, or a bigger patio, or a patio, and the upstairs units don't have a patio. and that justifies the increase for the rent in that unit, then you may have to, by transferring, you should be exempt from a transfer fee, but depending on the situation, the rent could increase if you move to that other unit. Now, as fair housing advocates, we always ask that the rent stay the same, and that your lease just be transferred to that other unit and you continue on the same lease. But that isn't always possible because that could be construed as a financial accommodation, which isn't a form of reasonable accommodation under the Fair Housing Act. So that's a little bit tricky. We always advocate that it stay the same, but you know, we don't have any law that supports us on that because the law clearly states that you cannot request a financial accommodation. Can a landlord charge you another security deposit when you transfer units? No, they should not do that. They should transfer your security deposit to the new unit. And so that can be tricky too, because sometimes they'll say, well, we don't know the state that you're leaving the old unit in, and we want to have something held back so that if we need to make any repairs, we have the funds to do that. And so sometimes they'll ask the person to pay another security deposit for the unit they're transferring to. And then the other unit that they're transferring from, once the housing provider goes over that and does an itemization of whether or not repairs need to be made, they'll return the remainder of the security deposit or the whole security deposit if the apartment's left in a state that it was in when the person, before the person moved in. So, you know, that's, if the person isn't able to pay another security deposit, that's where advocacy comes in, and we could try to negotiate with the housing provider that their security deposit be transferred to the new unit. Can a landlord force you to give a 60-day notice before allowing you to terminate your lease early? What do folks think about that? So a 60-day notice is probably going to be too much notice if a person is terminating their lease early. And one of the things to do first is look back at the lease. Does it say at the end of a lease you have to give 30 or 60 days in order to tell, before you tell the landlord, you need to have that amount of time when you tell the landlord, hey, I'm not going to renew my lease. And so that gives us a little bit of guidance. But generally, when somebody is terminating their lease due to a disability, 30 days is probably a reasonable amount of time that the landlord can request. And again, that's for the landlord to be able to put the unit on the market again, find another tenant, and then time for, you know, repairing the apartment or making it ready for the next person to move in. And so 30 days is probably reasonable. If the person wants to move out sooner than that, then again, that's where advocacy becomes really important, where, you know, we can try to negotiate lesser notice than 30 days, but it isn't always doable depending on, you know, where we are in the month, depending on where the tenant, you know, how quickly the tenant needs to be in their new apartment, and how much time the housing provider reasonably needs to be able to lease that apartment again. So there's a lot of factors that go into play there, but I would say 60 days is probably too long, and 30 days might be more reasonable. And so even though a person is going to terminate their lease early as a accommodation and should be exempt from fees and penalties, they still may have to give some amount of notice that they want to do that. Okay, so what are our next steps? If you need advocacy, or if you have questions about your fair housing rights, you can contact us, the North Texas Fair Housing Center. And on our website, you can submit a question or file a complaint. I also put our two staff that handle client issues. Camille, of course, who talked about the DV issues, and then our returning staff member, Dewey Marshall, is also assisting clients, and that's his contact information there. So you can email or call the numbers with extensions to reach those folks. Are there any other questions in the chat, Camille?
No, I believe we've addressed everything that has come through. But as we close out and you guys might think of additional information, you can type it in the chat. And if you don't catch us again, my email address is there, my extension is there. So if you want to connect offline, I am also available for that.
Wonderful. Very, very good stuff. Okay, well, let's do CEUs first, and then I want to talk about the clinic a little bit, but which we'll do in just a second. But I'm going to go back over the CEU information for those of you that are interested in CEUs. For today's webinar, we have CEUs for licensed social workers and licensed professional counselors, and we're set up in Texas. If you have a different license in Texas or you have a license outside of Texas, you're more than welcome to go through the process, get the CEU certificate, and submit it to them. I've had people tell me that they've worked in different places. Again, that's secondhand information. We're only set up in Texas, but you're more than welcome to get the certificate and try. Also, certificate of attendance are available. The rules for both certificates are the same. Today, we're giving 1.5 hours of CEU credits for attending. You must have completed the entire live webinar in order to qualify, and that is determined by the number of minutes that shows on the Zoom report we get for who attended. If you're joining us by phone only, if you could make sure you send me an email, not in the chat, but send me an email with your phone number and say you attended. That way I can correlate the phone number with the person, and that way you'll have credit, you'll get credit. But you also will need to complete the Google survey evaluation. We're asking everybody actually to complete the Google survey, whether you're wanting CEUs or certificate of attendance, or whether you're just here for the information, because our funders, it's part of our evaluating our how we're doing with our funders in regards to the goals we set in applying for this funding. The Google survey should pop up at the as you log off. If it doesn't pop up, I know some of you have pop-up blockers. If it doesn't pop up, you will also receive the link in the email I sent to you, the follow-up email that will go out after the today's presentation, probably later today. You will have 1 week to complete the Google survey, and then give us till the 1st of June to get those certificates out to you. You all, if you're, and I see several people putting stuff in the chat. If you're putting, if you have requests, please email them to us and not put them in the chat. It's hard to go back to this chat and grab that once we've closed all of the webinar out. So if you could email me, you all should have my email address. Also, the link to the survey, I'm sorry, the link to the survey and the link to the presenter slides will both go out in the follow-up email. So as long as you're showing as I've attended today, and that's somehow correlated with an email address. Like I said, if you're joining us by phone, send me an email letting me know the phone number that you attended with, so I can correlate those. You will receive that follow-up email. So if we can advance to the next slide, please. And we're going to have our second clinic. Our first clinic was great. Last month we did eviction prevention and eviction information. This month's clinic will be on neighbor-to-neighbor conflict and what you can do. Did you want to speak to that a little bit, Frances?
Yeah, so the clinic is it's actually a new thing for us. We've only done the one clinic last month, and we're still kind of trying it out to see if it's helpful for folks. And so that's a chance for you to bring any issues that you have. And, we want to focus on neighbor-to-neighbor conflicts, but that you can come with any housing question that you have. or any housing issue that you're experiencing, you can bring that to the clinic and we'll address your specific issues that you're having. So the way we set it up is not like this, where here you can only see the panelists. We set up the clinics like meetings so everybody can see everybody, and anybody can ask any questions that they want to ask related to fair housing or housing rights or any issue. But if you have a neighbor to neighbor conflict issue that you want to talk about, the clinic's the time to do that.
Great. And I'm just going to reiterate what Francis just said. We're doing that on Zoom, but we're doing it as in the meeting format, which is different than the webinar format. The webinar format, and especially because of the numbers that we get, you know, we had nearly 100 people on the line today. It's hard to open up the mics and have everybody have their cameras. And so the webinar format automatically is set up where the panelists are the ones who have the cameras access and the mic access. Now you can give it to people, but it's really hard to manage once you start doing that when you have this kind of numbers of people. But for the clinics, they are virtual. We will use Zoom, but we're going to do the meeting format. And in the meeting format, everyone will have access to the camera and to unmute themselves. And you know, to ask a question or to discuss an issue. And for that reason, we limit it to only 30 people. So the first 30 people who register will be the people that will join us for the clinic. So I encourage you to register quick. And that link to the flyer will also be in the first follow-up email that goes out later today. Any other questions or any comments or anything else? Well, very good. We're going to work on our topic for next month. Look forward to getting our email for next month's topic, and we'll continue to do each of these every month. And our plan is to do one training event and one clinic each month. So you all, thank you so much for joining us, and you all have a wonderful day. Francis, Camille, thank you very much. Great information.
Thanks, Marty.